The webinar will begin in 1 minute. The webinar will begin in 1 minute. Welcome everyone. We are pleased that you have joined us for today's webinar titled Surprises with Proposed RMD Regulations. The webinar will last approximately 20 minutes, and at the end you will be given an opportunity to receive supporting materials by email free of charge to you. You will also be told how you may email questions related to today's content to the presenter. Today's presenter will be Linus Sugis. Linus is the president of Advanced Underwriting Consultants. He and his team answer tax and technical questions posed by producers every day. Linus also spent 14 years working in the home office of a life insurance company in various roles. He also started, ran, and sold an estate planning law practice in the Nashville area. Linus will draw on his legal and life insurance experience during today's webinar, and here he is.
Thank you very much, Amber, and welcome everyone. I'm glad you joined us here today for surprises with proposed RMD regulations. Before we get into the meat of today's seminar, let's go ahead and figure out what it is that we're going to be talking about next month in June. That's going to be June 1st. You've got three choices: using the income tax return to better serve your clients. Second choice is free online resources to use in your business. And then third choice is a big mistake with a self-directed IRA. I am going to launch the poll, and I invite you all to vote for what it is that you want to talk about next month. The poll is open. Go ahead and vote, and we'll give you about 30 seconds to cast your vote. If you haven't yet voted, go ahead and do so. Give you just one more second. I'm about to close the poll. All right, next month we're going to talk about a big mistake with a self-directed IRA. Big mistake with a self-directed IRA. Thank you for participating in that. And thank you again for joining us today. That's June 1st for our next free monthly webinar. So let's go ahead and talk about the surprises with the proposed RMD regulations. And we're not going to get into a super lot of depth on those proposed regulations. They're quite lengthy and there's a lot in there. But there are some things that were surprises or clarifications a couple of things that were huge surprises that may adversely affect our clients, but we'll get into the details of that in a second. Let's talk about the first surprise, or the first thing that was clarified with the proposed minimum distribution regulations, and that is a twice inherited qualified account where a second death occurs after 2019. They have a liquidation deadline of the end of the 10th year after the successor beneficiary's death. So RMDs are still required based on the age of the first now deceased beneficiary, and the liquidation deadline is the end of the 10th year after the successor beneficiary's death. So remember, these are proposed minimum distribution regulations the IRS published about 2 months ago. They expect to finalize those regulations here sometime later this year. But the proposed regulations are kind of the way the IRS is thinking about these issues, and likely to be the way that these things will end up being sorted out. So twice inherited account, liquidation deadline, end of the 10th year after the second beneficiary's death. So that's been clarified. Second thing is that surviving spouses who have elected to treat the account as inherited may wait until the year the deceased spouse would have turned 72 to begin distributions. Okay, so just to add a little bit of background to this, if you're a surviving spouse beneficiary of a qualified account, like an IRA or a 401k account, then you've got two approaches that you could take to the inherited account. The first one is you could elect to treat the inherited account as your own, and a lot of surviving spouses do. They either in place have the account retitled into the surviving spouse's own name, or they roll the money over into the surviving spouse's own IRA, and both of those procedures are valid. However, it is also possible for the surviving spouse, instead of doing that, to elect to treat the account as inherited. And this can be an advantage, particularly if the surviving spouse is younger than age 59 and a half, because if the surviving spouse needs to take distributions from the account, if it's an inherited account, then the distributions, while they're taxable, they're exempt from the 10% penalty tax. Whereas if the surviving spouse elected to roll it over into their own IRA, they got to worry about the penalty tax prior to age 59 and a half on distributions. So if a surviving spouse has elected to treat an account as inherited, then the surviving spouse can wait until age 72. The deceased spouse would have turned 72 to take RMDs. We weren't sure that that we could wait until 72 because the old regulation said 70 and a half. Before the Secure Act, we had regulations that said 70 and a half for surviving spouse to take distributions. Now we're sure that the surviving spouse can wait until the year the deceased spouse would have turned 72. So that's been clarified. What's the next thing that's been clarified? Well, the thing that has been clarified is that if the account owner dies after 2019, right? So they're governed by the Secure Act. The account's governed by the Secure Act. And the account owner had not yet reached the required beginning date. Then the named non-spouse beneficiary has no annual minimum distribution requirement, but must liquidate the account by the end of the 10th year after death. Now, what's the required beginning date? The required beginning date is April 1st of the year after the calendar year after the account owner turns 72. That's what it is for most cases. For an employer account, if the account owner doesn't own the company, it might be later if they were still working at the time of death. But in general, it's April 1st of the year after the account owner turns 72. That's the required beginning date. And so if somebody dies before the required beginning date, and there's a non-spouse beneficiary, the non-spouse beneficiary doesn't have to take annual distributions, but simply must liquidate the account by the end of the 10th year after death. That's been clarified by the regulations. So the next thing to know from the proposed regulations is if we've got a non-spouse EDB, eligible designated beneficiary. That is somebody who's a child of the account owner, somebody who's disabled, somebody who has a chronic illness, or somebody who is no more than 10 years younger than the original account owner. They're an EDB, right? And so they've got the ability to choose either annual RMDs based on life expectancy, or they can choose 10-year liquidation. So those choices are available to the EDB. That's been clarified by the regulations. If we've got a look-through trust as the beneficiary, that's basically treated as a non-spouse beneficiary for the purpose of the stretch rules. That's a summary, but that's essentially what's included in the proposed regulations. So that's been clarified. One of the things that was up in the air that's been clarified is age of majority for the account owner's child. An account owner's child who is a minor is considered to be an EDB, an eligible designated beneficiary, until reaching the age of majority. There was some uncertainty over whether state law was going to govern whether someone over exactly what age is the age of majority. And the regulations say 21 for the purpose of these rules, the Secure Act rules. The age of majority is 21. So that's been clarified, and that's kind of a nationwide rule with regard to the proposed RMD regulations. So this next clarification is one of the ones that I think is a positive. So if we've got a disabled, chronically ill, or minor EDB, eligible designated beneficiaries, but they're not named directly. It's a trust that's been named as the beneficiary of the qualified account, and the trust is a see-through trust. The trustee can use the EDB status to extend stretch longer than 10 years, right? Even if there are other non-impaired, non-EDB beneficiaries of the trust, it is the special status of one of the beneficiaries of the trust that can be used to extend stretch longer than 10 years. So there's some planning opportunities there. If someone in the family is an EDB, an eligible designated beneficiary, and if our account owner is inclined to make a trust the beneficiary of the qualified account, stretchability is enhanced because we've got somebody in a special category. That's built into the proposed regulations. Now, again, these regulations aren't finalized, but that's what we've got, at least so far. So this next one's really the one that was the biggest surprise to me personally. And if you read some of the stuff that's been published since the proposed regulations, it seems like it was the biggest surprise to everybody else too. And that is that where we've got a qualified account owner dying in 2020 or later, who has already reached the required beginning date prior to death, the non-spouse beneficiary has an RMD obligation in addition to the 10-year liquidation deadline. And this is something that we didn't think was the case. It was something that most of us thought was in fact not the case, that we had no annual RMD obligation. The only obligation we would have is a 10-year liquidation obligation. But the IRS made a distinction as to whether the original account owner was taking RMDs or not prior to death. And so if the account owner was taking RMDs prior to death, there's an annual RMD obligation on the part of non-spouse beneficiaries. If they weren't taking RMDs or weren't obligated to take RMDs prior to death, then there is no annual RMD obligation, only a 10-year liquidation duty. So that's the biggest surprise that was clarified by the proposed regulations. It still doesn't quite seem to square up with the language in the Secure Act itself, at least in my opinion. There's a possibility that the IRS will rethink this, at least I hope so, and may come out and say that there is no annual RMD obligation. But you know, I think if you want to be absolutely safe and your client's antsy, you're going to tell your client to take an RMD out this year if they've inherited a qualified account from somebody, from a decedent who was already taking RMDs. They will take an RMD this year. For those people who are a little bit more conservative and are willing to wait, I wouldn't be in a hurry. I would recommend to them to not be in a hurry to take this year's RMD until the IRS finalizes the regulations and either confirms or overturns its position on the annual RMD obligation, where somebody was taken, the original account owner was taking RMDs prior to death. So that's the biggest surprise. There's now a deadline in the proposed regulations for a surviving spouse to make the election to choose between inherited account or the spouse rolling the account into her own account. It used to be there was no deadline. Now we've got a deadline. And the deadline that's in the regulations is the end of the year following the account owner's death, or the end of the year in which the surviving spouse attains age 70, if that's later. So it's the later of the year following the account owner's death, or the end of the year in which the surviving spouse attains age 72. And so you got to keep those things in mind as you're advising surviving spouses about their stretch choices. It's not an unlimited time to make the election like it used to be. There is a deadline, and if you've got a surviving spouse who's in the year they turn 72, that deadline is coming up fast. And so that needs to be thought about as we advise surviving spouse beneficiaries of qualified accounts. And then the last thing that I think is worth mentioning about the proposed regulations is that if a decedent passed away without taking the minimum distribution due for the year of death, it's the beneficiary's obligation to take it. In the past, it's been December 31st of the year of death, which presented a bit of a problem if we had people, account owners who died in December. The beneficiary a lot of times couldn't react quick enough. Well, the IRS has given a new grace period. The new deadline to take the decedent's RMD for the year of death is extended until the due date for the return, so at least April 15th following the year of death. So there is some time for beneficiaries to react without worrying about the potential for the missed RMD penalty. So there you go. We got a little bit of good news, another little bit of good news from the service. And so from my perspective, those are the biggest things from the proposed regulations that we end up talking about to callers. And we're hopeful that there'll be some consistency between the final regulations and these proposed regulations, with the possible exception of, I'm holding out personal hope that the service might remove the annual RMD obligation where the account owner dies after the required beginning date for the inherited qualified account or the inherited IRA. We'll see what happens there. So the good news is that if we've got an eligible beneficiary as a trust beneficiary, we get to bootstrap off of that eligible beneficiary and allow the trust to stretch based on life expectancy. We've got an extended due date for decedent's RMD for those who inherited accounts. So those are good newses, if that's a word. Bad news, mentioned it more than once, the annual RMD plus 10-year liquidation for many inherited accounts in the proposed regulations. Hopeful that that'll be changed, but not overly optimistic. We'll see what happens there. Obviously, the IRS has the opportunity to change its version of the regulations as things are finalized. But still, for where we're talking to account owners, where we're talking to account beneficiaries, I think the time is now for us to talk to them about what are in these proposed regulations and how it might affect them. There's still unanswered questions that the regulations don't address. One of the questions that's a pet question of mine is that we used to be sure that we could do a pre-death annuitization of a qualified account for life expectancy or shorter. And you know, from my perspective, if we've got somebody who owns a qualified account who has say a 35-year life expectancy and they choose to annuitize for 30 years, right? They've chosen a SPIA for 30 years while they're alive, a 30-year certain SPIA, and they die, you know, after 3 years, they've still got 27 years of annuitization that the beneficiary is going to take over. Well, that's longer than 10 years, right? So the question is that allowed? Can that work? Will that still be consistent with Secure Act provisions? And the answer is we don't really know yet. I've seen some stuff where people think it's an opportunity, but we're just not sure of that. And I'd be interested in what the final regulations say about that. And this really goes without saying, but I'm going to say it anyway. You know, our role in advising clients who've inherited qualified accounts, it's never been more important because these things are confusing. They're confusing even to those of us who are active in this business. For our clients who are lay people, it's just a tough thing for them to know. And so as we seek to serve our clients, we've got an opportunity to go talk to them and help guide them through sensible decision making in connection with the Secure Act rules and with these proposed regulations and hopefully the final regulations that will follow soon after. So I'd like to thank you again for joining us today, and I will turn the program back over to Amber to wrap us up. Amber?
Thank you for joining us today. As a reminder, if you would like to receive supporting materials, feel welcome to email us at asktheexpert@advancedunderwriting.com. You may also email questions related to today's webinar. Feel welcome to join us for the next webinar on the first Wednesday of next month, June 1st, at this same time. Next month's webinar will be titled, "A Big Mistake with a Self-Directed IRA." You can also find an archive of past webinars on our YouTube channel, Advanced Underwriting Consultants. Please subscribe to our channel. It helps us to keep making free webinar content. Today's presentation will be posted on our YouTube channel by the end of this week. Finally, for more information about the services that Advanced Underwriting Consultants offer, including phone consultation and newsletter licensing, feel welcome to contact us at 615-224-1291. That's 615-224-1291. Thanks again and best wishes for continued success.